Counsel, it seems to me that you're really asking for an equivalent of a Miranda warning that somebody would have to give, the prosecutor, maybe even the judge, going through all the things that you're required to. What exactly, what are the elements of what they must, you must tell the defendant so that you don't leave any, strings untied?
So there's a distinction between the first question presented and the second question presented. If the judge said absolutely nothing, we'd still be here on a contract defense. There's no warnings. It's just there's 30 years of, actually 34 years, where this has been the law. We think in terms of the second question presented, all the judge has to say is that you may have a right to appeal. You should look at your plea agreement. That's it. There's no other warnings. There's no nothing. So that's the second question presented. But on the first question presented, we're just arguing the government is enforcing the plea waiver. We're saying it's subject to one of contract offenses or a miscarriage of justice exception. So that's all to brief on remand. This has nothing to do with what a court would have to educate the defendant about.
Well, I think it does have to do with that, and it seems to me that the court is the only one that can do it. If you're the defense attorney, I don't know, you want to advise your client, of course, but, if the judge says something that's not right, it seems to me that the lawyer's in a tough position because the judge has given them an opportunity to raise this after the fact, if you think and so it would be odd, I think, for the lawyer to stand up and say, oh, Your Honor, remember, you've got to tell him that he can't do this, or otherwise it might not be valid.
So on the second question presented, we are literally arguing a straight litigation forfeiture waiver. All we're saying, this is on the second question presented, all courts hold what you just said, except for the Ninth Circuit. It doesn't matter what the judge says. Except the Ninth Circuit. What we're trying to argue on the second question presented is when the judge said you have a right to appeal, given the back and forth on the medication condition, and when the prosecutor said, Your Honor, I believe, I know, that two things happened. One, the defendant detrimentally relied on that in bringing the appeal and exposed himself to a breach. And two, and I think the better argument is, had the prosecutor spoken up, we would not be wondering had the court imposed this bizarre medication condition thinking that there could be a right to appeal, and that's a simple remand. Well, the more important question is the first question presented, where all 11 circuits, this has nothing to do with what a court would advise. You just sign a plea agreement, and they're broad waivers, and that's it. Defendants don't bring these because it's an alleged breach. You do have these rare exceptions where it can meet a contract offense or be a miscarriage of justice. The castration example, a pregnancy ban, the government's view, race, mandatory medication, tough. That's it. You sign the appeal waiver. That's absurd when everyone from Elon Musk to billionaires to corporations to mom and pops can assert contract offenses. The government doesn't even tell you why this contract, unlike any other contract in the entire universe, can't have a defense.
Ms. Blatt,